This conference will now be recorded.
All right, good morning. We're going to call to order the special magistrate hearing for today, which is already Tuesday, February 1st. This is the Town of Ocean Ridge. My name is Amity Barnard. I'm the special magistrate presiding over this morning's hearing. It is officially 10 o'clock according to Verizon. First order of business is there are quite a few folks in the room, so we are going to swear everybody in at the beginning of this hearing. So if you are here to testify on any of the items on this morning's agenda, if you could stand and raise your right hand for me. Do you all swear affirm to tell the truth, the whole truth, and nothing but the truth? Thank you. So it looks like on the agenda this morning, we have several violation hearings and one status/fine assessment hearing. The process essentially is as follows. When you hear your case called, come to the podium up here. The town will present its case first in the instance of both violation hearings and fine assessment hearings. They'll present their evidence, any testimony of any witnesses. You as the respondent will then have an opportunity to come to the podium, present any testimony or evidence you have that you'd like me to consider this morning. At the end of that dialogue, I will make a formal ruling. As you know, I just swore all of you in, so this is a quasi-judicial hearing. You are testifying under oath this morning, so keep that in mind as you testify. At the end of the discussion and the presentation of evidence, I will enter an order on each case reflecting the ruling for this morning. If you have any questions along the way, please feel free to stop me. With that, I'll turn it over to the town for the first case. I will let the record note that I adopt the minutes of January 4th, 2022 without any revision.
Okay, thank you, Your Honor. Christy Gott on behalf of Town of Ocean Ridge. Your Honor, the first case on our agenda today is 90 Island Drive South in the Town of Ocean Ridge. Property owners, according to the Property Appraiser's Office, are Cynthia and Robert Herrig. This is a violation hearing for violation of 6751 of the Town's Code of Ordinance that involves work without a permit for the installation of a new front door. Your Honor, we have the town's building official, Randy Guy, here to testify, and just by way of overview, this case was initiated back in November of 2021. On a Saturday, it was observed that the front door was being installed without a permit. We do have the entire file here, and perhaps since it is lengthy, while Mr. Guy testifies, I believe there's an attorney. Is there an attorney?
I'm their daughter exclusively, but I am an attorney in Michigan. But I'm here as their daughter.
And I think I've already provided you with the town's information, but if you want to, I can let you look through that now and to help facilitate the hearing. And then Dorian can provide his testimony, unless you need more time with this.
Nice to meet you.
Nice to meet you too. Okay, Dorian Guy, our building official. Mr. Guy, you've been sworn in?
Yes, thank you, Attorney. So, good morning, Durrani Guy, building official of Town of Ocean Ridge. So 90 Island Drive has been undertaking a lot of small improvement projects for the past 2 years. In November of 2020, there was a discussion that we had inside this room with the owner's brother and with the owner, Robert, on the phone in Michigan at the time, I believe, to discuss a project that was undergoing at the time, was undergoing review. And the reason why that project was ultimately altered was because the project we had pointed out required review by the Planning and Zoning Board. Based on the value of the work that was done, the project had exceeded what we call substantial improvement. Exhibit 8 inside the packet had a letter that was sent on July 26th. And that letter was in response to the final permit that was issued at this location, which was for a garage door. After the garage door was issued, they had slightly exceeded the 50% threshold that required the project to go in front of the Development Plan Review Board and for the entire property to be updated to the present code, which is what the code requires. The town has adopted this community rating standards to get credits from the FEMA, the federal government, to offset flood insurance. It's a program that the town is very proud of. All residents currently get about 20% discount on their flood insurance rate because the town has enrolled in these programs. And because of that, the building department is required to enforce these rules. The owner has been advised of these rules for at least a year and a half, and for at least a year before the violation of the door installation without a permit occurred. So we have the letter as a part of the document here explaining that the garage door was the final permit that would have been issued at that time. And it reads, after the issuance of permit 21950 for the garage door replacement, this property has been determined to be just under the substantial improvement threshold. Any additional permit applications until March 8, 2024 will be required that the home meet the new construction guidelines per Town Code Ordinances section 66.26. And this letter was sent to the Michigan address that we have on file, and we have a signature as to the receipt of this letter. Subsequent to this, an application came in on August 9th for a new garage door. When we did the initial review a day later, we sent the same letter that was sent to the garage door, explaining to the applicant that you have been advised previously that you will not be issued any other permits prior to 2024 unless the house goes to development plan review and abides by the new standards.
Mr. God, let me stop you there. Was the August 9th permit submittal for 2021, was that for a front door?
A front door, yes. So on the 12th, the application was withdrawn for the installation of the front door.
The 12th of
August of 2021. On Saturday, November 13th, the police department was informed that there was work happening at the location, and I believe police officer Frederick Stan is here. Right. Was the one that responded to that. And at that time, a new door was being installed. I was made aware of it the following Monday and was sent pictures and the video of the actual install, which is also pictures are actually included in the exhibits. So the door was installed. The door actually has been disguised because they seem like the old door was cut and secured to the new door. So as of today, the new door has been installed without permits and is still in place. So the violation, as noted, still exists. Thank you.
Do you need more time to look at the file?
I'm all good.
Okay.
I mean, can you come to the podium and give your appearance?
Yeah, of course.
Thank you. Can you state your name for the record, ma'am?
Hi, I'm Angela Carrick. I'm the daughter of the property owners of 90 Island Drive South, Rob and Cynthia.
And the town has given you their evidentiary case file. Do you have any objection to their evidentiary case file they'd like to enter into evidence?
No, I do not. Oh, I'm sorry. Can you repeat the last part?
Do you have any objection to the evidentiary case file that the town would like to enter into evidence?
No, I do not.
So with that, for the record, I'll enter composite exhibit 1 without objection. Let me just give me a second to look through these.
Of course.
All right, I see here right at the front, we have an updated violation hearing notice with a signed green card. You are here, so I will find in this case that there is good and sufficient notice. So go ahead now with your testimony. What would you like to say in response to what you heard from the building official?
Of course. Well, hello, everyone. Thank you for having me here. As much as this is not an ideal way to spend a Tuesday, it's better than Michigan. We're getting 10 inches of snow. So anything is better than that, right? I'm here on behalf of my parents, and I understand everything that's been going on up to this point to a degree. And I did look through the exhibits. Thank you, Attorney Gadat. I am not here to argue that the door was installed without a permit. I think that kind of speaks for itself. There's no arguing that. And I know my parents are happy to pay the permit fee and the reasonable fine. But what I'd like to speak to is this substantial improvement threshold that was spoken about by the building official, Durrani Guy. Section 6625 does discuss this definition, and there is an exception that was not stated, that any project for improvement of a building required to correct existing health, sanitary, or safety code violations identified by the building official, and that are the minimum necessary to assure safe living conditions. I understand here that a building official, Durrani Guy, was not informed of the door before it was moved or changed. And I also understand that that is a faux pas or a mistake on my parents' part. But I would like to just acknowledge that this violation was called in on Saturday, I believe November 13th at 10:42 a.m. My parents returned to Michigan that following Sunday, November 14th. I would assume the building department and building official is not here on a Saturday or Sunday. I actually don't know. I would hope you guys get at least a weekend off. But they had to return to their home state, needed to secure their house. This is reflected in the police report. And then it was advised to, I believe, my mother that this would be passed to the building official for review. This door, as shown in the affidavit from Scott Wilbrett, who's a managing partner at Red Group Construction, LLC, discusses how this door is compromised from a structural integrity perspective. It was likely installed in the early to mid 70s. It had multiple areas of rotten wood, including the jambs themselves, that will no longer hold fasteners for repair and does not secure itself with the locking mechanism without more force than should be necessary. A door in this condition that swings into the home is extremely vulnerable to failure given our environment and potential for tropical storms and hurricanes. This door has outlived its lifespan. I understand that this door was installed without a permit. That is, again, not up for discussion. But this subsection 1 of section 6625 exists for the exclusive and elaborated purpose of this door. This is a safety code violation. Having a door that does not lock and being thousands of miles away is a huge problem. The door, as far as I'm aware, was original to the 1970s. And I did the math roughly while I was sitting, that's about 50 years. And this environment is not hospitable to a wood door for 50 years. This door, although it was installed without a permit, that the issue is all about what is the reasonable fix for this? Like, is it a permit? Is it a fee? What are we trying to do to correct the damages? And they're happy to pay the permit fee and a reasonable fine. The violation does still exist because it was the installation of the new safer door that does actually lock. The door was 50 years old. It swung inside, which is not best practices for fire code. It did not lock, and there's no discussing it was installed without consulting the building official first. This new door is arguably better. And while I do understand that we are discussing the substantial improvement threshold, going through the code as a layperson would, or even as someone who reads medical records all day in Michigan, the substantial improvement terminology is a little confusing. There's two different altering definitions, one in the beginning of the code and one at the end. It's very reasonable that someone who is confused thousands of miles away or just doing a cursory glance would go with the more lenient definition that's defined in section 1.3 that states, and I won't belabor the point, you guys know the building code. But at the very end of this, I think it's subsection C, it says this term does not, however, include any project for improvement of a structure required to comply with existing health, sanitary, or safety code specifications, which are solely necessary to ensure safe living conditions. I can't think of anything more fundamental to ensure a safe living condition than a locking door. And I think that might have been where my parents came from when they made the decision that they did. Again, the door was installed without a permit. That's exactly why we're here. What I'm trying to ascertain and what I know my parents are most concerned with is what is the correction for this? Well, how do we rectify this? Because it does qualify under an exception to the substantial improvement threshold, namely the one required to correct existing health, sanitary, or safety code violations identified by a building official, it should not, in my understanding, implicate the further substantial improvement definition that was stated. And with that, I can give you, magistrate, a copy of this if you would like.
Sure, has the town attorney seen that?
Yeah.
Any objections to that being
No.
entered into the record? You could bring that, I'll include that in the file, please. And what's the town thinking today in terms of remedy?
Well, Your Honor, I think we might need to hear further from Mr. Guy on this substantial improvement issue, because I would point out that the exception that's been pointed out to the substantial improvement threshold is that it's a safety code violation identified by the building official. This door was actually, as Mr. Guy testified, this door permit was applied for in August of 2021. Once they were advised of the substantial improvement threshold issue again, they withdrew the permit. And then apparently, I guess, waited until November to then go ahead and install it without a permit. It was never identified by the building official as a safety code violation. So we don't think the exception fits the substantial improvement threshold. The recommendation that the town initially had for this was to provide them 60 days to obtain an approved permit for the front door. However, what that would require due to the substantial improvement threshold is that they would have to go before the Planning and Zoning Commission for the development plan review, which is a substantial process because the entire property needs to be brought up to code, and that would require site plan and building plans and things like that. The 60-day timeframe was going to be the recommendation, and if they showed good faith efforts of moving forward during those 60 days, the town would be willing to come back and ask for a further extension just so that we can make sure that this property is on the right track for compliance. Depending on your ruling on the substantial improvement told. However, if you believe that they've satisfied the exemption to that definition, then our recommendation for compliance would be substantially less, because now they just need to resubmit for the front door permit and obtain that permit to have it installed. But before that, perhaps we could hear further from Mr. Guy on the front door issue and the substantial improvement.
Thank you. So this letter was written on November the 6th, which is after the violation. So this type of discussion usually happens when the permit is applied for, which was back in August.
And when you say the letter, you're talking about this letter
Yes,
from the
this
lawyer
letter
from
that I'm
December
looking at.
6th?
So, and also the work was done on a Saturday when it is known that staff is not in town. So had it not been for, a call that the police department had gotten, we would have not known. And again, right now, the door seems to be the old door because it's secured to the new door. So unless I had walked up to do the notice, I would have not even known myself that the door is still in place.
So you're
because
saying,
it's
when you say
got-
the old door is the new door, you're saying the door itself, but there's a new frame? Is that what
There's
you're-
a new frame. The old door was taken out, but it was cut and secured onto the new door. So it would seem like the existing door is still in place. It's been disguised.
Okay.
Okay, so that's what happened there. So yes, the door was in bad shape. And if I'd gotten this letter in August, my first question is, why do we need to put in a $3,600 door? You could put a door in that is not as expensive, would still meet the code and would still be in compliance with town rules. The issue is value. This property has spent $38,000 on windows, $52,000 on eaves and roof. So the property could have modified the work that they did to deal with safety issues. There was a lot of other things, a new dock, new deck, new boat lift, new driveway, a lot of things that happened on this project. That if safety was the primary concern of the owners, they would have dealt with that long before. And we have advised the owners that what we've told them about substantial improvement happened in my presence at least a year and a half ago. So they've been aware of what the requirements are.
And the town's concern is, the reason for the not issuing a new permit is that you can't piecemeal improvements, right? That's what you're trying to eliminate.
Well,
So the rules-
Initially, we had hoped that they followed the town rules, which is when you're doing this type of improvement, you do it wholesale. And you put everything under a singular permit, and if it does exceed the value, then do the proper thing, follow the rules, and do the development plan review, and you do the overall project. But it was not done like that. It was done piecemeal, and it could have been done at any time in the past. It's just that the owners chose to do it this way. And again, I do agree that the old door was in bad shape, but if this letter had come to me, I would have said, okay, let's do the minimum that's required to get it up to standard and still follow town rules, is what I would have said. And that's actually still my position.
Your Honor, I think you're correct in that, it's the town rules regarding substantial improvement is to prevent, these piecemealing, because the logic being, we want the entire property brought up to code so that you don't continue to have non-conforming structures that are just repaired and remediated without bringing the whole property up to code. The other issue is obviously our PRS standard for compliance with FEMA rules and the discount to the town, ensuring that properties don't violate this provision also keeps to keep our community rating high, so we afford the discounted flood insurance. So there's several different issues at play for why this matter was brought forward for your consideration. It's one of those things where it seems to be, let's just ask for forgiveness instead of permission type of situation. The pictures that were taken when the police responded on that Saturday also seem to convey substantial improvements were made within the interior and other improvements based on review of the plans that exist. It's really up to your ruling based on what's been presented so far in terms of if this qualifies as an exemption to the substantial improvement threshold. The town's position is it does not, because it was not identified as a safety issue by the building official. It sounds like from the letter written after this that it was just hard to close an old door. It doesn't sound like it presented a true safety issue. So we would ask that they be found in violation and be required to go through development plan review. The town is willing to give more time if they show good faith effort within the next 60 days of moving towards that process. And then we would ask for a fine of $100 per day thereafter if they don't rectify the violation. The town has incurred costs of $188. And we also ask that those costs be imposed, and I think at a minimum, the violation has been acknowledged. Whichever way the magistrate decides it, work without a permit has been acknowledged. So we would ask the town's cost of $188 be imposed.
Your Honor, can I address the additional testimony by Building Official Durrani Guy?
Yes, ma'am, go ahead.
Thank you. I understand, and I have done a cursory review of the costs, and granted, I have no clue what a door costs. I'm a serial renter, so I don't know how much these things cost, but the installation and approval of several of these things that were permitted, like the windows and everything else, the cost is high because the cost is paying for hurricane readiness and hurricane safety. 90 Island Drive is arguably, with the windows, more hurricane ready and more hurricane safe than it was when my parents came into possession. So while it is allowable under the building code to install like situated or previous existing windows in accordance with the 1970s regulation that were existing, that's not what is best for the structure, and that's not what's best for the community. I understand that my parents could have hypothetically limped this house along. And I know in a letter from the building department, I believe one of the July letters, it says that because we're close to the threshold, we will have to hold off on permits until, I believe, 2024, maybe March or May of 2024. That does not take into account the ever fluctuating just damage and regular wear and tear a house takes. Attorney Gadat, I'm sorry if I'm pronouncing your last name wrong. Okay, that's what
fine.
Okay, Godot, that's what I thought, and then I panicked. But as Attorney Godot stated, she stated that she, in her interpretation, the door was just hard to close, and it was an old door. I would fundamentally disagree with that. I have not been involved with this house a ton because I was in law school and doing several other things when they purchased it. But the door was a 50-year-old door that had seen hurricane after hurricane and had existed with relatively little maintenance or upkeep. This is more than just a door that's hard to close. This was a door that wasn't able to be locked, a door that you can't secure against the elements. And as my parents, the owners of the property, live in Michigan primarily, and arguably they're only here maybe 3 times a year, generally they're normally here 3 times a year. That's a big risk to take on a 50-year-old door.
But I think to the building official's point, the caliber of door could have been less to solve what you're alleging is a safety issue. That's, I think, his point, and that further trips the substantial improvement threshold based on the monetary value. So the more expensive door you put in, the faster you approach that threshold and the faster you trip that.
Correct. And I think the issue is how I interpret it. And granted, this is not my specialty. I'm just showing up to get out of the cold. I think that the issue is they applied for the permit. They had the contractor that they were planning on using. This calculation includes the labor and everything else. I don't know if they had already paid for the door and that's why they used it, or I don't know what the reasoning is. But I do know that it was not intentional that they decided to replace the door when the town was not open. I believe they arrived on a Friday night and they flew out on a Sunday morning. And then following the installation, there wasn't a time where they could have called the department themselves because the police were called, I believe, mid-installation based on the time frame from the report. Well, I'll be the first to state my parents are not the easiest people. There's not some greater scheme to defraud the city or flagrantly violate the ordinances. There's been a Keurig in Ocean Ridge or on Island Drive since 1973. My dad and uncle grew up here, like, we love it. There's no intent to make this city less than what it is. There's just an intent to secure our property, make it the best it can be within the regulations, and hopefully enjoy it, and then ideally for me, pass it down to me so I can have it. But this rigid implication of these standards, it encourages properties to not modernize and to not comply because it is so tricky. The house, 90 Island Drive, it's the same on the outside it's the same on the outside, and I'm assuming on the inside, I actually don't know. Since the 1970s, it's that old Florida style that's becoming increasingly hard to protect. We purchased it from Carol Edge, whose father built the house in the 1970s. So it's only ever had 2 owners in its existence. It's not likely to get flipped or put into a spec house. It's going to stay in our family. And we would like it to be as safe and existent as possible.
Okay.
Your Honor, I think the building official has something to add.
Go ahead,
So,
sir.
Your Honor, just a correction that with regards to the inside, based on the plans that's included here, from the vantage point of the video and the pictures that we have on the day of install, it's apparent that significant work has occurred at this location. The interior of the house doesn't look anything like the plan for the original house. It looks like a modern house on the inside.
And Your Honor,
Without permits, by the way, there were no permits ever for the condition of the house.
so to complicate matters, if you find that they've met an exception to the substantial improvement threshold, and all they need to do is apply for and obtain a valid permit for the front door installation, the town is going to have to go cite them for what we know of now as interior renovations to the property, and they will need to go through development plan review process to have those permitted, because since we do have videos and you have photographs in the file that shows substantial improvements to the interior that differ from the plans that the town has of record, that will be the next violation. So at some point, they are going to have to go through the development plan review process, whether it's for the front door or what would be next. That's up to the magistrate.
And I guess, so, and I'll ask Mr. Guy this directly. In your letter states that, your letter from July 26 lists the exception that the respondent is relying on. In your experience, or in your opinion as the building official, does the door, was it a correction to correct health sanitary or safety code violation? That's the determination, and the town attorney is asking me to make that determination, but I don't believe that I have the authority to make that. As the code reads, as I read the code, you're the one to determine whether that door was corrected to solve a safety concern. And your previous testimony was that it's not. Is that, based on what the respondent said, is that still accurate?
Your Honor, again, this came after their claim of the door being, there's no need for me to inspect the door. However, a 50-year-old door, I would understand, probably needs updating. And my issue with this whole thing is we don't need a $3,600 door. It could have been repaired, or a door in the region of $1,000 would be way sufficient to deal with that issue instead of going $3,600 and being way past substantial improvement.
So you're saying that they could have replaced the door and not exceeded the 50%?
Absolutely. We could have still worked with them at the time. That is why we require permits before for the town to make its review and give you information. And if this letter had come in, that's the discussion that would have happened. So the door, is a glamorous door that has been put in not for reasonable safety only, but it was way beyond that. And that's the issue, is that it's now past substantial improvement. And had it been done properly, it would not have done that. They would not have had a nice door, a really fancy door that's there. No, that's being covered up, by the way, and being seem like it's an old door. I don't know what the reasoning is for that, other than hiding it and make it seem like it's not as fancy as it is. Or to hide the fact that a new door was installed. I'm not certain. You know, again, it seems like an old door, but it's really a brand new.
Understood.
That was-
Go ahead.
I just have a question to follow up on that. Mr. Guy, since the exception to substantial improvement doesn't have a value limitation on it, as the building official, do you believe the door would have qualified for the safety exception to substantial improvement?
A door would qualify, not this door. Because when I make those judgments, I try to still stay within the code. And again, I mean, my determination is that the door that was installed is way beyond what was reasonable necessary to give the required safety that this letter is arguing.
I guess the question is whether the existing door prior to its replacement, whether that you would have deemed a health, sanitary, or safety code violation.
Again, just based on the reasoning that it's a 50-year-old door that was there for that time, the standards for doors back in 1950 do not equate to the current requirements for hurricane impact doors. And if that's the reasoning, I would agree. I personally did not investigate the door. I had no reason to. But we could have solved it with a Toyota and not a Mercedes-Benz, is what I'm saying.
So, Your Honor, the exception language that's in the code talks about it's a safety code violation identified by the building official, which I think is, he's confirming it would be a safety violation to have this old of a door. And that is minimum necessary to assure safe living conditions. So there technically is sort of a limitation on the cost of it, because what you're really supposed to do is just repair it so it's now safe.
Correct.
And I think what Mr. Guy's point is, they went above and beyond to put in the new door that was Mr. Guy, was that the same door that they applied for the permit for?
Again, I didn't do significant, but based on the appearance, the shape, the size that was presented in the original permit, it would appear to be the same door.
Can I address some of the additional things that have been brought up? That's not me. No, I don't know.
Right.
So I would like to just touch on this idea that the doors being disguised. As the police report reflects, our neighbors called this in. So there is a level of not feeling respected in your space. And I think that is why the door is obscured from the outside. I don't believe in my interpretation of my parents' opinion that it's done with any purpose to conceal anything. I think the old door is what was left they had at the house at that time. They had to leave the next day after this was called in, and they felt that they had nosy neighbors. Well, I don't know if that's accurate or not. I know our neighbors have a very cute dog that I love looking at, but I don't know the dynamics that play beyond that. So I don't think it's a disguise. I think it's more of just trying to feel safe and protected and knowing that people aren't looking in your windows, trying to find the next thing that they can call the police on you for. And as far as the interior, the permit set or drawings that I have from, I believe, March 9th, 2020, the structure is, I believe, as the house is now. And that's the open, how this is. I don't know what the permits that the department is referring to. I'm assuming a 1970s drawing set. It's in the exhibit.
I
It's in the exhibit.
No,
Yeah.
they ever went forward with that plan.
No, that was withdrawn by.
But it sounds like that may be better addressed at the next time you appear. This is
Right.
not for this morning's
Okay, that-
consideration. I think we're limited to the
Yes.
award here this morning.
Which is perfect, because I was not prepared to discuss that, but I didn't want to leave it unaddressed.
And Mr. Guy, I'm not seeing pictures in my file. Do you have photographs on your computer?
And then also in the,
Is there anything else in your file, attorney?
This was.
They might be in the tablet.
Oh, yes, it's on the tablet.
Oh.
So this is the front door. And I think these are pieces of the old door that was.
And you'll get a chance to see these, so just hold on something.
And that's the interior of the house, which is wide open. According to those plans, there's a vestibule on the hallway.
Just limit it to the door.
Vestibule. Different glass.
And then you're saying that pieces of wood slats from the old door have been affixed to that?
Yes. Okay.
Okay. Are they on that tablet? Can you show those to the respondent and ask them if she has any objection? What I saw from Mr. Guy was two photographs, one of a glass door and one of a door with wood slats on it.
Okay.
That one.
And then was this, Mr. Guy, was this the other one you had the magistrate with the,
It's the last one in the list.
this?
Thank you. Yeah, I have no objection.
Okay. So with that, while we're on the record, I'll enter into evidence the respondent's exhibit, we'll number that number 12, and then the photographs will be exhibit 13 without objection. Okay, anything further?
No, nothing further. Thank you all for your time.
Okay, don't go anywhere. Anything further from the town?
Nothing from your honor.
And town attorney, you said 60 days compliance. I think,
Right, we said 60 days compliance, obviously with the town's willingness to come forward and ask for a continuance, if they're showing good faith effort towards going through the development review.
under the new ordinance, how would that work? Because
Um,
today would be the final,
We would not move forward with
you would not
in
record the lien.
position, right, we would not report it. He would come back before that timeframe. So it is, so the March, wait, so that would be April hearing, which would be,
The fifth.
yes, yes,
So
so
you'd be asking
April
for compliance
5th.
date before that?
Yes, so if the compliance date was April 4th and they were, well, I would say compliance date actually April 5th. So if they're making good faith efforts, we could come on that day and ask for a continuance of the April 5th date to give them more time because that is a process. If they, or I guess we could do it, yeah, April 4th is compliance date and April 5th, come to ask for either a fine assessment if nothing's being done, or to request a further continuance if they're making good faith efforts to.
But under the new ordinance, there's no fine assessment hearing date set
I'm sorry.
currently, right? So that's what I'm wondering.
If we set it, then you're correct. If we set it for compliance for April 5th, we will come back and either ask for the continuance or we will reward it.
Okay. So does that make sense what she's saying? The town's process now is, if this is a violation hearing, my order will likely require you to comply by a certain deadline. If you do not comply by that deadline, the town then is authorized to record the order that I signed, which becomes a lien against your property. You don't come back. Previously, they changed their ordinance recently. Previously, you came back to a second hearing.
Yes.
Many jurisdictions have gotten rid of that because it's cumbersome from a time perspective. So what the order will say is that if you don't comply by the required deadline, the town is authorized to record that lien, and there's a process by which you can challenge the fines, and it's all set out in the ordinance, but you don't come back here for a fine assessment.
Okay, yeah, so it would be on April 5th or whatever day, that would be when I would need to contact you or my parents would and say, we've made good faith efforts, or we have not. Basically, and it would go forward from there, but there wouldn't be this kind of
there would not be a second.
Okay.
Correct, unless the town especially sets it or some other process,
Okay.
but yes. And I mean, the issue for me is based on the testimony and based on your admission, it's very clear that there's a new door, there's no permit, so I can't not find that you're in violation. I do think there are some details to be worked out in terms of the substantial improvement. Again, I'm not gonna make a determination. I think that's for the building official to make. He has made, his testimony is that it's a two-pronged statement is what he's asserting. And what I've heard is that first, I think he's telling you based on your testimony that there was an issue with how the door was functioning, but that second prong is not in his testimony being met. So what I'm hearing, and correct me if I'm wrong, is that they do not fit within that exemption under the substantial improvement based on the type of door that was installed. Is that correct?
That's correct, Your Honor.
Okay. So with that, in case 2021-013, as I said previously, I find that there's good and sufficient notice for this morning's hearing. I will find that the respondents are in violation of section 67-51 based on the testimony of the building official, as the testimony of the respondent, as well as the evidentiary case file, which has been entered into the record as composite exhibit 1 without objection, with the addition of exhibits 12 and 13, 12 being respondents exhibit, 13 being photographs of the violation. I will require the respondents to comply with section 67-51 by April 5th, or assess a fine of $100 per day. And I will, based on that finding of violation, award the town's administrative costs for this morning's hearing in the amount of $188, payable within 30 days. You will get an order that reflects that in the mail. And good luck on the next step.
Thank you.
Thank you. Thank you, Your Honor. Your Honor, the next case that we have is, on today's agenda is a fine assessment hearing, and as you correctly pointed out, we're no longer doing these, but this case was originally started under the prior ordinance, which allowed for the second hearing for the fine assessment. This is property address is 8 Inlet Cave Drive in the town of Ocean Ridge. Property owners reported the property appraiser's office are Patricia and Albert Thrower as trustees. The initial order finding the violation was entered August 3rd of 2021 with an initial compliance date of October 4th of 2021. Your Honor, if you recall, at December 6th, at that hearing, we continued this. They had applied for variance. This is for a floating dock. And the variance hearing was November 17th. They were approved by the Board of Adjustment for the variance. So we continued the compliance date to December 6th in order for them to obtain the permit for the floating dock under section 6477. They have applied for the permit, but they have not obtained a permit as of yet. I don't know if anyone's here on behalf of, good morning.
Are you the respondent, sir? Yes, please approach the podium. And I think we'll hear from the building officials. Just hold on just one second.
Your Honor,
Excuse me, Your Honor, can I just, I'm having a little bit of a back problem, so if I could
You
sit
can
as
sit, go
much
ahead,
as
sir.
possible.
Yes, not a problem.
Your Honor, the town would present Doria Guy, the town's building official, to testify as to the status of the violation.
Thank you. The applicant did submit paperwork and was given a series of comments, mostly of which we needed a DEP approval as well, and proper drawings to scale of the required installation. There was actually a back and forth, and I do believe attorney may also inform us of what was done, is that an attorney had challenged for requirement for a permit, and there was a discussion as to, you know, whether or not they needed a permit, and I'm not sure where that was, but the town's position is that based on the definitions in 64-77, G, seawalls, bulkhead docks, dolphin pilings, floating docks, and davits or board dock appurtenant to a seawall or bulkhead shall require a permit. I think that's very clear to us. And the floating structure as installed is connected mechanically to the seawall. And that has been our position. And, there has been much delay in this permit. And as of today, we still have not gotten the required documentation in order to process this application.
Okay, so they applied for a permit, but a permit has not yet been issued because there's additional documentation that's required to issue the permit.
That is correct. And there was also a delay with the arguing of whether or not it was even needed from the applicant.
And do you know what date they applied? Is that in the file?
Your Honor, I believe that they applied back in November, shortly after the hearing on the on the variance, the Board of Adjustment. I have that date. Hold on one second. The permit was submitted on November 24th of 2021. And Your Honor, I have the town's exhibits for this fine assessment hearing. It includes the variance application, emails to property owner, an email to the Board of Adjustment regarding the application, the town costs, inspections, the initial order finding violation, proof of mailing of the order finding violation. I can provide this to the property owner to review.
I'll give it back to her.
Christy, do you want to give, Christy, do you want to give Mitty the tablet while he's looking at, so she has the tablet and she can.
The tablet?
Mhm.
Okay. You're gonna have to, mine's out too fast for me.
Oh, it's-
Yes.
Oh, this in this folder, everything he has.
Do you have any objection to that case file, sir?
No,
And can you state your name for the record?
sure. Robert.
Your Honor, just to follow up on Mr. Guy's testimony, I did receive correspondence from attorney for the property owners, Mr. Grower. The discussion in that correspondence with the attorney was whether or not a permit was required for the floating dock. The property owner's argument through their attorney was that it was just moored there and not mechanically connected to the seawall. Our response to the town's position is that it's mechanically connected to the seawall, and that therefore it's not just moored, and it does require permits under the code section 64-77. And the property owner has been on notice of the permit requirement since at least at the time they went to the Board of Adjustment hearing. There is also a belief that they knew about that permit requirement before that time, but they were certainly at the hearing and on notice at that hearing.
And Mr. Guy, the previous order would have put them on notice of that failure to obtain a permit, correct? And I'm looking here, you sent the previous order,
Mhm.
certified mail?
Yes.
Yes, Your Honor, and the,
Was it also posted to the property?
Yes, sir.
Your Honor, as I mentioned before, they did submit for the permit on November 24th of 2021. The building official responded with comments on December 7th of 2021. And those comments are what remain, as Mr. Guy mentioned in his testimony, to be responded to in order to have the permit finalized.
And so based on the grant of the variance for the Board of Adjustment, this can be permitted so long as you get the required documentation. Correct?
Yes, sir.
And is there a signed green card in that paper file?
Let's see. For the order,
Yeah, there was an updated notice of this morning's hearing, it looks like. Or an affidavit of posting, I just don't see that in here.
it could be right here.
Is that yes, there you go, because I just got the green card.
Yes, the order continuing this to today's hearing. There is proof of service through certified mail that was delivered on November 1st of 21.
Wait, what?
Oh, wait, I'm sorry. This is for the continuance to December. Then the continuance,
Looks like the order was also sent via email.
Yes.
Mr. Guy, do you know what date you posted the property?
Should be.
I'm searching around.
You never responded, I just want to make sure.
Your Honor, to be expeditious here, we received it.
Okay, very good, sir, thank you.
So I don't know if there's, I'm not disputing that we didn't get it. I don't think that's.
Here you go. It was posted on, and I have on January 3rd, 2022. I have an inspection report from the building official that he posted it.
And because this is, sir.
Yep.
Are you okay to stand at the podium, just so that the recording picks you up?
Sure.
So you've heard the building official say you're aware that you've applied for a permit, but you have not been issued a permit. What's your response in terms of the additional documentation that's required?
Well, first of all, we applied for the permit quite quickly after the hearing and our grant for from the Board of Adjustment. So my initial plan was to proceed with getting the permit. I thought it was something I could handle myself. Did not want to make this into a giant project. However, as we got further into it and I started going through the process, I realized that it was above and beyond my capabilities because of the extensive permitting requirements through the state of Florida and the Army Corps of Engineers to get this approved. So I started doing it myself. I contacted the Department of Environmental Protection from the state of Florida. I was told I needed a letter of exemption for the permit, for the dock. But keep in mind, this is, a fairly small structure. I waited probably a month in order to get an appointment with them to have a call over the phone. All this keeps dragging on. It's very difficult. So I finally spoke to this very nice woman on the phone, Lucy Brandenburg is her name. She's from the Department of Environmental Protection from Florida. She went through the whole process of filling out the application. And I thought that I was progressing. And then we got to the end of the call and she said, now you have to, show pictures of the property and blah, blah, blah from Google Earth. So I go through that process. I realized the pictures of my property from Google Earth are from when we were redoing the seawall. So the whole backyard is ripped up and it's not an accurate representation of my property that now exists. So after I came away from that, I said, this is not going to go well. So I have subsequently, and I can provide you with a copy of the contract, I've subsequently now hired a coastal engineering firm to assist me with getting these permits. Once I got done with Ms. Brandenburg, she then said, well, now you have to go get a permit from the Army Corps of Engineers. She sent me the form, and it was daunting to say the least. So at the end of that process, I determined that it was above and beyond anything that I could do myself. I was hoping that as a homeowner, I could do something because this is hopefully a fairly simple process, but that does not appear to be the case. So I would be happy to submit this and keep this copy if you wish. This is
Can you give it to the county attorney first?
Yeah.
Okay. Thank you, sir.
So we are proceeding as expeditiously as we can, given the requirements for all these different permits. And I have also contacted the installer of the floating dock, and he is supposed to be getting back to me with the architectural drawings. I have not gotten them back from him. I have been on the phone with him several times. As you can imagine, people are very busy and they're not particularly cooperative in terms of doing something where they're not getting paid to do it. He's already been paid to install the dock, and I feel like he should provide that information to me as part of his installation.
Does the town have any objection to the respondent's exhibit?
Your Honor, do you have any?
Yeah, I don't, Your Honor, but it's been almost a year, and the original requirement of the town was for him to remove this structure. And that, I believe, could be done. And that would take care of the pressure, for lack of a better word. And then when all the documentation is in place, then it is installed. So that's one way of achieving compliance.
What is the town seeking here this morning?
Your Honor, the order finding the violation gave compliance till December 6th. Otherwise, a fine of $100 per day. Fines began to accrue on December 7th at $100 per day. So as of today's date, if my calculation is correct, 57 days have accrued at $100 per day. The town's incurred costs of $124 for today's hearing. An administrative review of this case. So at this point, the fines are just accruing. As Mr. Guy stated, the quickest compliance would be to remove the floating dock, get all the required approvals, DEP, Army Corps, and the town. And once that's in place, then have it reinstalled. If they want to leave it in place, then fines will continue to accrue until the town's permit is obtained. And I believe the town's permit can be obtained. Does it require to also have DEP and Army Corps to get the town's approval?
So if we're able to pull up the documentation and or initial review, it would be very similar to what DEP is requiring, that we needed proper surveys and photograph describing the installation, which is the same thing that DEP is saying that we're saying. So we haven't gotten the proper documents that clearly describe the dock, the setback, the size of the floating structure being installed, which are pretty much, consistent with what DEP is also requiring. So we haven't gotten the required documentation, which is also what DEP said.
But to the town attorney's point is that, can you issue the permit without both of the state and the federal DEP and US Army Corps permits?
No, actually, the DEP Army Corps, I believe it's one agency that will issue that permit.
The same agency issues it, but I think it's two separate documents.
Yes, two separate documents. But the answer is that is our requirement for the town.
So you cannot issue, the town will not issue the building permit until you have those permits in hand.
Correct.
Your Honor, I represent the neighbors who have an interest in this, and I would just like to let you know,
Yes,
as soon
hold
as
on,
you
just
get a
one-
chance to speak. Yep.
So, sir, what the town is asking me today, and based on the previous order, you were required to comply by December 6th. So the town is asking me this morning to assess a fine in the amount of $5,700.
Well, I find that very unreasonable, Your Honor. I'm sorry, but we have been making a very good effort to, follow the permitting process that the town has requested. Permitting process is difficult. However, let me just say that I would be more than happy to, if the town says that the quote unquote permitting not required if the dock is moored, which Mr. Guy told me means it's tied by ropes, I would be happy to have the installer come back and do that, tie the floating dock with ropes, if that would satisfy Mr. Guy. I can move the floating dock, which I don't understand why that would be necessary because we already have the Board of Adjustments approval to keep it where it is.
Well, but the Board of Adjustments approval is just locational. You still are required by the code to get a permit. So
We are
until you
proceeding,
have that permit.
and we are proceeding with that as expeditiously as possible. So I'm trying to understand what does the town want me to do? Removing it is very difficult. As I said in my letter to you back in August, it's a very heavy structure, and to get it out of the water now with all the barnacles. But I'm happy to if they feel that moving it to another location is somehow going to make them happy, I don't see how that would. But certainly if they want me to take off the mechanical attachment and tie it to the dock, then I would be more than happy to do that. I don't think that's a very good idea from my perspective, from a structural point of view, but I would be happy to do that. But we have proceeded as rapidly as possible once the hearing was over in terms of getting the permit. And I would disagree with Mr. Guy. I understand that he is following the letter of the law, and I appreciate that. But we have provided him with many pictures and drawings of the size of this dock. There's no dispute of that. It's 10 feet by 10 feet. He understands that. He's been over to the property. He's seen it. So I'm a little confused as to why he seems to be so unclear as to what the dock is, because I think he knows what it is.
Well, I think that was all, I mean, you've already been found in violation, so I don't know that we're here to rediscuss that. I think now it's just a matter of getting the permit issued, and as you stated, and as you testified.
I'm working on it.
You're working on it, but my issue is that you have this letter from your coastal engineer, and it's from a couple of days ago. So.
Well, as I said, I proceeded forward in good faith from the beginning, doing this on my own. And I met, unfortunately, with some resistance because of the process, and I received the letter from Mr. Guy, and it listed the things that he wanted me to do. So one of them was to get the permit from the Department of Environmental Protection along with Army Corps. So when I contacted the Department of Environmental Protection, and it began this delay process, which took some time. There was a form to be filled out, and I thought that I could do it myself. I did it. I got to the end of the form. They wouldn't provide me with the letter of exemption. So then I had to start calling them on the phone. I started that process. We went back and forth. I set up an appointment. The earliest appointment I could get was for, I think it was January 14th. So I did the phone call with this Lucy Brandenburg, and we got to the end of the phone call, and I realized that this was not going to work out. So at that point, I called back the installer, and I said, listen, I need help getting a permit. He gave me the name of the gentleman who I called. The gentleman got back to me 2 or 3 days later and said, I'm sorry, I can't help you. So then I contacted a good friend of mine who's an architect, an engineer in the area, Mr. Marsh. He gave me the name of this firm, and I contacted them immediately. I spoke to a gentleman over there who put me in touch with the head of the company, and they said, we'll send you a contract, and I've sent them the money, and I'm proceeding with getting it done as quickly as I can. I'm happy to do whatever the town wants to satisfy them. If they want the dock removed, I suppose it's possible to do it. It's going to be difficult and obviously expensive.
I don't think I'm not sure that it's a matter of what the town wants. I think the town is telling you that there's an alternative option.
Which
You
is,
can either remove it to obtain compliance or get the permit issued. What the town is testifying to is that if you continue to go through the permitting process, which you're pretty far along, the fine is going to continue to run until you have that permit issued by the town. Jonathan, do you have a copy of the previous order?
Yeah. Do you want the one granting the continuance or the original order finding the violation?
The original one. I'm trying to get back to when this was originally cited.
It's Exhibit 6 in the file that you've admitted into evidence.
Let's see when this-
Yeah.
So my previous order was from August 3rd, and then the town subsequently gave you a continuance.
So it was August and then they went back for October where they had, we provided the status that they had a certified and then they went back and then that's when,
I believe your letter indicated that we were okay until we came before the Board of Adjustment. The Board of Adjustment hearing got postponed. another
Yeah, no,
month.
that's my recollection is that the town tried to accommodate, give you as much time as possible to guide you through that process.
As soon as the Board of Adjustment hearing was over, we began the permitting process. So there was no delay as far as I was concerned. I didn't start the permitting process because prior to the Board of Adjustment hearing, because obviously we couldn't do it without the order from the Board of Adjustment.
Right, and has your marine engineer given you any indication of how long this is gonna take, how much more time you have?
Well,
to get through the process?
the question is, I think the Army Corps is the question. They're the longest one. I don't think that the Florida Department of Environmental Protection will take very long. I would think, I don't think it would probably take more than 60 days, maybe even less. I was 95% of the way through getting the letter from the Department of Environmental Protection until I got to the pictures. And then I realized I might be having a problem if I submitted those pictures. So Army Corps, the question is whether they have to do a seagrass survey. As you know, seagrass is not, surveys cannot be done this time of year. They have to be done in the springtime. It's May or April. So if the seagrass survey has to be done, then they couldn't do it until then, and we'd have to wait until that season.
Okay. Anything further from you, sir?
Anything
You got
further?
anything further from you,
Yeah,
sir?
we're doing everything within our power to get this brought into proper permit.
Yeah, I understand.
I'll do whatever I can. As I said, I will also be happy to take off the mechanical attachments if Mr. Guy feels that would satisfy the town's requirement for a moored floating dock, which apparently does not require a permit.
Yeah, so that's gonna be a matter for you and the building official to determine. We don't have to get to that here today.
Okay,
In terms of how you achieve compliance, that's not what's before me this morning. What's before me this morning is that, I have testimony on the record from both you and the building official that you still do not have a building permit, which is what my previous order required compliance by December 6th.
well, I thought I provided all the information they required when I
Yeah, I
submitted the
understand.
permit,
Yeah,
and then he responded with a list of many things that I didn't have. And then I started working on that process.
Right.
I think I got that December 7th. So that's when I started working on all the things he said that I didn't have. And I'm still obviously working on it.
In the process, okay.
Yeah.
Okay.
Your Honor, from the town's position, we're just presenting potential options of how we can bring it in compliance sooner by either removing or boring the floating dock or continue through the process to actually get the permit and bring it in compliance. The town doesn't take a position of how they do compliance. So until that compliance is reached, the previous order, which was not appealed, remains intact, and it's $100 a day. Obviously, once they come into compliance through the town's code, they can request a reduction of the fine before the town commission. And in order to keep this project moving forward towards compliance, we would ask that the fine remain at $100 per day. And then, of course, the property owner can ask for a reduction once they come into compliance.
So let me just clarify that because I was a little confused by that. So if I were to moor the structure to the seawall, I would be in compliance with the town, is that correct?
You'll have to coordinate with the building official, but under our code, if it's moored and not mechanically connected to the seawall, properly moored, the building official can declare you in compliance. If you remove it, then that's another option. Or if you continue through the process and get all the documentation that the building official needs and get your permit approved, then you're in compliance as well.
Okay, I'm happy to proceed on both fronts, Your Honor. Happy
Yeah,
to proceed with the
these-
permitting process. I'm happy to contact my installer and try to get them to remove and moor it to the seawall to bring it in compliance.
Right, and as the town attorney indicated, they don't compel the manner of compliance, they just make a determination as to compliance, depending on what you choose to do.
Okay.
So what he's saying is, should I testify today that you can come back before the commission and request fine reduction? I would advise you that if you do that, you need to show very, very, better than good faith effort that you're doing this as expeditiously as you can, getting things timely, getting things done as quickly as you can will only serve to assist in that fine mitigation request, which is certainly not guaranteed on the part of the commission. With that, if you don't have anything, do you have anything further, sir? Any additional testimony?
No, I would just ask that take into consideration the fact that we have been showing good faith efforts to proceed as rapidly as we can with a very difficult and, unfortunately lengthy process with these type of permitting issues. And
Okay.
this is also the first time that I have ever heard from the town that if I moored it and kept it where it was, moored it to the seawall, that the town would be okay with that. That's the first I've heard of that.
Your attorney is aware of that. His letter to me indicated he's quite aware of that issue.
Okay, I think the question between the two attorneys, whether if it was, as it exists now, considered to be moored.
Understood.
That was our contention, that it was quote unquote moored.
Yeah, and based on the previous order, I don't think we need to dispute further.
No,
The
we're not,
previous pictures on the previous hearing.
we're not getting
It
into it.
was mechanically attached, so that it was already determined that you're in violation. We have an additional party here that is requesting to testify. Are you aware of that, sir?
Yes.
Okay. Do you have any objections to them speaking?
No.
Okay. If you could be Christina, I'll bring you back to the podium once they're finished. If you could approach, ma'am. Does the town have any objection to the
No.
additional party? Your name for the record, ma'am?
Ali Eichner,
Can you spell your last name?
EICHNER.
Okay, and your affiliation?
I represent the Board of Torres, who are owners of lot 7 and McKay Drive.
So you're counsel for the neighbor?
Correct.
Okay, go ahead, ma'am.
We are here today to call attention to Lot 8's pattern and practice of ignoring the code and the ordinances. And we wanted to urge that Your Honor find Lot 8 is still in violation of the town's code and order removal of the structure. Despite being granted the variance on November 17th, Lot 8 continues to violate the code and the required permitting process. It is also believed that the structure remains out of code and impossible to place within code as currently constructed, such as the rack that is in place on the floating dock. The history is concerning and merits that Lot 8 behavior be halted. In 2018, Lot 8 built a dock in violation of the setback requirement. And when notified of this violation, Lot 8 was forced to remove the part of the dock that encroached upon the setback requirement. Armed with the knowledge of this setback requirement, and despite the town of Ocean Ridge's enforcement in 2018, the owners of Lot 8 chose to build a new dock, but in this time, the form of a floating dock structure, significantly closer to the property line of Lot 7 than what is allowed, and again, without permit or permission, demonstrating an ongoing and continuous disregard for town ordinances, basic principles of law, and proper respect for neighbors' rights. On April 15th, the town notified Lot 8 that this floating dock structure was in violation and mandated its removal. However, instead of removing it in blatant disregard to the request, they applied for a variance. And as discussed at the code enforcement hearing on August 3rd, Your Honor previously found that the structure was in violation and ordered Lot 8 to comply with it. But once again, in blatant disregard to your order, Lot 8 has failed to achieve compliance to date, just demonstrating an ongoing and continuous disregard for the town's ordinances and official rulings. And as discussed on November 17th, the Board of Adjustment voted to approve a variance for the setback, permitting the floating dock to be located 3 feet from the property line. And the granting of this variance just sets the dangerous precedent of allowing and potentially even encouraging violations of the code, with approval sought only as an afterthought. And it wasn't until after the variance was granted that Lot 8 applied for this permit. And again, as further discussed, on December 7th, the town advised Lot 8 of what was required, what was needed from them to get this permit and become in code compliant, but they've continued to achieve this compliance with the code. So we urge Your Honor that you just find that Lot 8 is still in violation and order removal of the structure, because they've just continued to ignore the required permitting process. And as is, the structure doesn't meet code and cannot properly be permitted in our opinion.
Okay, anything further? Thank you, ma'am.
That's it. Thank you.
Anything for you, sir, in response to that?
Well, I'm not sure what she's talking about in terms of a dock violation. There's never been a dock violation while we among owners of the house. The dock that we currently have is permitted and approved by the town, and it was permitted, I believe, in around 2000, and we bought the house in 2010. So the existing dock was permitted, I believe, shortly after we purchased the house. When we purchased the house, we realized that there was an open permit on the dock that had never been properly closed. So when we purchased the house, the previous homeowner had to complete that process, and he did, and he got the permit. We then had to replace the seawall on our property, and that was several years ago, and that has been permitted, and that permit is closed, and that permit, I believe, is fine as far as I know. I checked with Ms. Armstrong, and she told me that that permit is done and closed. So I'm not sure what violation it was ever in terms of a dock. As far as the floating dock is concerned, I would agree that we put it in without a permit. I did not realize that. It was completely my mistake, but I read, I guess the guy installed it, thought it was okay given the town code. It was not, and I agree that it was in violation. And as soon as we started working through the process, and we are still
In the process, understood. Thank you. Anything further from the town?
No, Your Honor.
Okay, case 2021-008. I find that based on the testimony of town staff and the documents in the case file, so there is good and sufficient notice for this morning's hearing. I will enter into the record without objection the town's evidentiary case file, composite exhibit 1, with the addition, sir, can the town keep this?
Sure.
Copy? The additional document from respondent, it's a document dated January 29, 2022 from Ismayer and Stubbs Engineering, Inc. I'll admit that without objection, composite exhibit 1. And based on the testimony here this morning, sir, I understand that these are always difficult cases because I'm sort of in a pickle, as they say. I do understand and I sympathize with the process. I have been involved in many dock permitting cases. I know it is a process. However, I do also understand the position of the town to request a fine to ensure that you continue to get through that process as quickly as you can. So based on what I've heard today, I'm going to find that you continue to be in violation of section 64-77 for failure to have been issued a permit for the dock structure based on the testimony of town staff and the documentation in the case file. and as well as your own testimony. And I am going to assess a fine that the town is requesting for the period of 57 days. That's a fine of $5,700 for those 21 days, and continuing to accrue at $100 per day until you achieve compliance. I will also assess the town's administrative costs for today's hearing in the amount of $124. Would the town also like it, were the previous administrative costs paid?
Yes, Ms. Armstrong has confirmed the previous.
Okay,
costs have
so
been
we'll
paid.
limit the administrative costs to $124 for today's hearing. I will encourage you to go forward and achieve compliance, however you choose to do that, as quickly as you can, because as you're hearing today, the fine will continue to accrue. Certainly, the town attorney has given you a mechanism to request mitigation of that fine down the road, but because of the fact that you have not complied today, I am going to assess that fine. We will get an order in the mail reflecting that ruling. And good luck with the DEP and the Army Corps. It's a process, but it is achievable. So I hope you can get through the rest of it as quickly as you can. And with that, I'll turn it back to the town for the next case.
Thank you, Your Honor. I don't know if we have any further respondents here today. Your Honor, the next case violation hearing is against Ronald Kerrigan. This is a Kerrigan subdivision improvements that haven't been completed on time. Your Honor, the next two cases after that, the one involving Summit Ocean Ridge at 6600 North Ocean Boulevard and Lava Enterprises LLC at 51 Spanish River Drive. In looking at the notice of hearing that was sent out, we didn't provide case number 2022-003 and 2022-004, the 10 days required time frame for notice of hearing. So what we'd like to do is to reset those. And if you're available, perhaps reset them this month instead of pushing them all the way to March.
Okay, but for the purposes of this agenda, you're going to pull them because you.
Yeah, because we have a notice issue and I don't want to proceed knowing that the notice of violation, notice of hearing didn't provide them the 10 days. So if you have availability later this month, we will send out the amended notices with a new date and time to ensure that they get the full 10 days notice for the hearing.
And that's for ENF on the agenda, is that right?
Yes, for those two cases. I'd also like to reset the one on Ronald Kerrigan because I did leave him a message last week to potentially work on a stipulation. He had informed the town manager he couldn't be here today. And I left a message and I completely forgot to follow up with him. And so I don't want to proceed without giving him a courtesy of follow-up because we were going to talk about a stipulation so that he wouldn't have to be here. And the town is working with him on these improvements. So I would like to reset all three if possible for later this month.
Okay, so that one you like to pull too and just.
Yes.
Just give a new notice, okay?
Yes.
Do you have to not have a date in mind?
I don't know if Carla Armstrong, if you have a date in mind that would work, given all the other hats that you wear.
And I guess if they're being pulled from.
I mean, we could do it the week of the 14th through the 18th. Tracy, do you have a specific date? I'm okay with that week.
And if these are being pulled, we can set this outside of the hearing as well. If you're just pulling these, we could coordinate schedules outside.
Okay.
That's fine.
Once we adjourn, if that's.
Yeah, that's fine. That's fine.
So case 2022-005 is pulled from the agenda. Case 2022-003 is pulled from the agenda. And case 2022-004 is pulled from the agenda. And with that, I don't see anything further. Is there anything further from the town?
Nothing further, Your Honor.
And with that, we'll adjourn at 11:29.
Okay, thank you, Your Honor.